Great. So in this paper, Michaela and I are going to comment on steps forward and backwards in enhancing the protection of animals under South African law. And we argue that COVID-19 ought to create the impetus for heightened protection for animals under the law. And we discuss a proposed ban on animal testing for cosmetic purposes as one example of the potential for enhanced protection for animals. So to start off, what is our conference all about? Well, we thought it might be apposite to explain the links between COVID-19 and environmental harm. And there's a general scientific consensus that the bat is a probable species of origin for the 2019 novel coronavirus, because the virus shares 96% whole genome identity with a bat from Yunnan province. However, scientists point out that COVID and MERS-CoV usually pass into intermediate hosts such as civets or camels before leaping to humans. And this fact indicates that SARS-CoV-19 was probably transmitted to humans by other animals, and scientists believe that the probable origin is the pangolin. And so that context in mind, and of course there's some debate about the origins of the disease, but I've done quite a lot of research to figure out what is the consensus at this point. And that origin of the disease and the idea that it occurred from transfer from animals to humans should give us some pause. Because importantly, COVID-19 is not an isolated instance of the transfer of disease from animals to humans, or zoonosis. And this is by no means a new phenomenon. We'll of course all be familiar with rabies and the plague, which have been around for centuries. And in 2004, Bengus and others explained that human activities such as the destruction of biodiversity creates the conditions for new viruses and diseases. Of course, they didn't speak of COVID at the time, but now we have it. Then in 2008, Jones identified that of 335 diseases that emerged between 1960 and 2004, 60% were the result of zoonosis. The cause for this increase in the transfer of disease from animals to humans has been linked to disruptive human behavior that is bringing animals and humans into closer contact than ever before, including human habitat destruction and biodiversity loss. So zoonosis has thus been described as the hidden cost of unregulated economic development, because natural barriers between virus host animals and humans have been reduced, and wildlife is under stress. Further, the erosion of biodiversity causes a proliferation of species most likely to transmit diseases. The others all die. And Vidal and several other scholars point out that the trade in animals is a huge part of the problem, because now diseases travel further and faster. And all of this must point to a need to change the way in which human development occurs, including by enhancing the protection of animals and nature more broadly under the law. So under our law, animals are currently recognized as mere legal objects over whom humans exercise dominion. Some people say non-human animals, because of course humans are animals as well. And the laws largely represent an anthropocentric approach, or human-centered approach to the protection of animals, treating animals as commodities to serve human interests. And Michaela will discuss some examples of this phenomenon in our law. So in light of this position, several scholars call for the reform of the laws regulating our relationships with animals in particular, and nature more broadly. And David Bilchett, who we're privileged to have with us here today, is one of the most prominent scholars writing and thinking about this area of law, and we'll allow him to elaborate on his animal rights approach. So what we want to speak about is in broader terms the need for the reform of the law, and Michaela will then deal with a specific example. So in 2008, Cormac Cullinan told us that the fact that humans are an integral and inseparable part of the Earth system means that we cannot flourish in the long term at the expense of that system. So he pointed out how humans are inherently connected to nature. And so that means the primary purpose of our governance systems must be to ensure that humans maintain mutually beneficial relations with other members of the Earth community. He said it's far too late to argue that it is too difficult or too expensive to move away from a system of governance that entrenches our separation from nature and our role as exploiter and user towards one that creates a framework for respectful and mutually beneficial relationships. And he reminds us that it's not for us to magnanimously decide to recognize rights of nature or animals. The real question is whether we can correct distortions inherent in contemporary legal systems that prevent the law from seeing the reality that members of the Earth community already have what we humans term rights, in the sense that they have intrinsic worth that should be protected, otherwise we all die. And in fact, we can seek guidance on this perspective that Cullinan offers us from African customary law, because our law could be transformed to afford greater protection to animals and nature more broadly through the eco-philosophy of Ubuntu. Pursuant to Ubuntu, first, morality is relational. The only way to develop one's humanness is to relate to others in a positive way. Secondly, positive relationships with others are defined in communal terms rather than individual terms. There are no individual human rights. Humans are in a relationship with the entire cosmos, and human interrelationships pursuant to Ubuntu are merely a microcosm of relationality with the universe, including its past and future generations. And that's in part because of the belief in ancestors. So no person, according to this philosophy, is complete in herself, but is fully human in as much as she remains a part of the web of life, including creation and the earth. And human life is then embedded in and related to ecological life. And this philosophy and the unity of humanity and nature it represents were very prevalent in pre-colonial Southern Africa as a means to manage and conserve biodiversity and human relationships with biodiversity. Our current environmental laws, in contrast, are rooted in a colonial approach towards the relationships amongst humans and nature. With the introduction of colonial era conservation came the myth that nature is separate from human civilization. So there's us, and at the time it was us white Europeans, and then nature. So nature was considered to be the absence of human impact, and especially European human impact. Now, we can take some guidance from the phenomenon. So Ubuntu could be incorporated into our law through the phenomenon of environmental constitutionalism, which entails the recognition that the environment is a proper subject for protection in constitutional texts and in the courts in South Africa and elsewhere in the world. And environmental constitutionalism is an emerging phenomenon worldwide. It carries with it, in theory, the elevated protection of environmental norms and the potential to influence societal values and perceptions towards the environment. South Africa has been heralded as a pioneer of environmental constitutionalism, at least on paper, as our constitution provides not only for a substantive right to an environment not harmful to health or well-being, but also procedural rights, such as the right to access to information, and other substantive rights that are arguably mutually reinforcing of the environmental right, including the right to culture. Now, having recognized that the environment is a subject worthy of constitutional protection, the crucial issue then becomes, how can this protection be implemented, including by the courts? And you'll see if you study the Constitution, animals are not expressly conferred with any rights, and there's arguments against that David can speak to. So there's no express provision that affords animals rights. However, in 2016, the Constitutional Court found in the NSPCA case that animal interests are protected by the environmental right, including as a result of the state's duties to promote conservation and secure ecologically sustainable development. and the court found that animal welfare and environmental protection are two intertwined values. And so environmental constitutionalism has thus been expanded in South Africa to include at least some protection for animals, and potentially this can grow. I would argue that it requires further expansion to recognize the extent to which humans and nature are part of an earth community, and the notion of Ubuntu, which has been utilized as an interpretive tool in the Constitutional Court in the context of the advancement of other constitutional rights. And the incorporation of Ubuntu as an aspect of environmental constitutionalism could be inspired by the Ecuadorian Constitution's preamble, which expresses a commitment to build a new form of public coexistence in diversity and in harmony with nature to achieve what they refer to as summa causae, a very similar concept to Ubuntu. And so if we were to adopt this approach, it wouldn't be a big reach, because according to Mokgoro several years ago, group solidarity, conformity, compassion, respect, human dignity, humanistic orientation, and collective unity are, among others, key social values of Ubuntu that broadly align with the values of the Constitution. And so transformative constitutionalism invoked in our courts could allow our courts to provide enhanced protection to nature and rights, building on the NSPCA judgment. Next, Michaela will contrast the judicial protection afforded to animals with problematic amendments to key animal legislation recently introduced into the legislation, into Parliament. And she'll also discuss a proposed bill tabled to enhance legal protection of animals in the South African context for protecting, or at least for testing animals for cosmetic purposes.
Okay, I hope everybody can hear me. Recently, there have been a number of judicial pronouncements recognizing the sentience of animals in South African law, the most significant of which being the NSPCA judgment of the Constitutional Court, which Melanie has discussed. This was the first judgment of its kind to grapple with the environmental right by recognizing the importance of placing intrinsic value on animals as individuals. A handful of judgments have since adopted this reasoning, offering enhanced recognition to animal welfare, one of which was discussed by Peter Cantor this morning. In the NSPCA judgment, Judge Kampepe states that South African courts have started and are required to afford robust protection to animals and their welfare. But is this really the goal of the legislature? As Ashby puts it, the South African government has recently tabled amendments to legislation that could massively expand the wildlife industry to become mass meat suppliers to the world. This is in reference to the controversial proposed amendments to the Meat Safety Act, as well as the amendment to the Animal Improvement Act. The proposed amendment to the Meat Safety Act introduces wild animals such as rhino, hippo, and giraffe for human consumption, and thus paves the way for the commercialization of bushmeat in South Africa. The amendment to Table 7 of the Animal Improvement Act reclassifies certain wild animals as, including lion, cheetah, zebra, and most shockingly of all, rhino, as domestic animals. These wild species can now be manipulated as farming stock for no discernible purpose other than human greed. The recognition of the welfare of animals as a constitutional issue, as well as recognizing animals as individuals with intrinsic value, indicates a shift towards interspecies injustice for animals in South Africa by acknowledging that the interests of animals are deserving of as much protection as human interests. Thus, as the courts continue to take steps forward for animal protection, the legislature continues to take us 2 steps back. This is problematic since the executive and legislative branch are obliged by Section 24 of the Constitution to take reasonable legislative and other measures that advance animal interests and recognize their intrinsic value in view of the Constitutional Court's judgment in NSPCA. the proposed measures arguably run counter to the constitutional mandate imposed on them. Certain members of the public lean towards the stance that animals are deserving of enhanced protection, which has influenced the tabling of the Animals Protection Act draft amendment bill, a possible indicator of a less anthropocentric approach towards interspecies justice, as the draft bill aims to criminalize and ban animal testing for cosmetic purposes and shows heightened recognition of the interests and moral worth of animals. In South Africa, there is currently no legislation that explicitly deals with animal testing for cosmetic purposes. Animal testing is implicitly regulated by the Animals Protection Act, but such regulation is inadequate and insufficient for this purpose. Criminalizing animal testing for cosmetic products promotes the view that sacrificing the lives of animals is not worth producing products that have no medicinal or scientific value. Thus, the individual value and interests of the animal is placed above the selfish desire of humans to look and feel more attractive to other humans. Additionally, the draft amendment bill provides a criminal sanction for juristic persons that commit acts of animal cruelty, including testing cosmetic products on ingredients or animals. Products or ingredients on animals. The draft amendment bill was tabled in 2017, and the fact that no further developments have arisen since then proves that the legislature is hesitant to move towards a less anthropocentric approach to the protection of animals. This is regrettable, particularly in a time where we ought to acknowledge that the abuse of animals contributes to harming Earth systems more broadly, including through zoonosis. The testing of cosmetic products and ingredients on animals doesn't only entail the physical testing, but a full life cycle which ends in the animals being disposed of and runs a risk of potentially spreading disease to humans and animals alike. The logical conclusion of animal testing is that after the animal is subjected to harsh, painful, invasive tests, it gets killed and thrown away. There is no safe way to dispose of the large toxic mix-up caused by animal testing. One of the advantages of the draft amendment bill being passed is that pollution in this regard can be vastly reduced by banning animal testing completely. According to Groff and several scholars, people living in areas near to incinerators designed to dispose of waste from animal testing are exposed to chemicals through the air or contact with the soil. Bronchitis and decreased life expectancy are health hazards posed by exposure to air contaminated by incinerator waste. Some toxins, such as mercury, that are released through incinerators can travel long distances in the air as well as water and are known to cause neurological damage and birth defects, resulting in developmental delays and cognitive issues. Gases that are released can cause cardiovascular and respiratory disease and contribute to acid rain, smog, and ozone formation. Public drinking water is also at risk of being contaminated by animal experimentation due to the fact that the water treatment plants which are responsible for the purification of our public water are ill-equipped to filter these contaminants out of drinking water. What is even more frightening is that the contaminated carcasses are in some cases sold to poor communities, which increases the spread of disease to one of the most vulnerable groups in any society. The criminalization and banning of animal testing for cosmetic products purposes could aid in keeping the water resources on which all life on Earth depends free from toxins caused by animal testing and limit the spread of disease. The presence of antibiotics, endocrine disruptors, cytotoxic cancer drugs, and other drugs in rivers, streams, and drinking water has serious negative effects on the planetary health, including on humans as well as fish and other aquatic species who are exposed to the contaminated water, and the animals who consume the contaminated fish or drink the contaminated water. According to Bowles, alternatives to animal testing are procedures which can completely replace the need for animal experiments, reduce the numbers of animals required, or diminish the amount of pain or distress suffered by the animals. It is stated in the memorandum to the draft amendment bill that where methods are not possible, provision should at least be made for these animals to be kept in appropriate enclosures. The draft amendment bill does not explicitly suggest alternative measures to animal testing, which is a major flaw. Alternative methods to animal testing used in countries where such testing is banned, such as the United Kingdom, the European Union, India, New Zealand, Israel, Brazil, and Turkey, include tests that involve the use of human cells and tissues, which are known as in vitro methods, and experiments on human volunteers. Furthermore, researchers are developing computational models that crunch huge quantities of research data to predict the effects of certain products on organisms, thus replacing animals with algorithms. These alternative methods are not affected by species differences that make applying animal test results to humans difficult or impossible, and they usually take less time and money to complete. It would be ideal for South Africa to implement these types of alternative methods. However, regulations regarding the scope and application of these alternative methods will need to be drafted and implemented. In conclusion, as Melanie has so eloquently argued, we should be recognizing that if we abuse nature, we bring pandemics onto ourselves. And so we need to be thinking about the ways in which we can put an end to the abuse of nature and how we can make changes as individuals. Visit the Beauty Without Cruelty website and have a look at the Humane Guide to see which brands in South Africa sell products that are certifiably cruelty-free. I hope that if you take anything from my presentation today, it is that vanity is hardly a justification for cruelty towards animals. Thank you, Dr. Murcott, for giving me this opportunity and for believing in me just as much as you believe in this topic. I appreciate everything you've done. Thank you.